Hi, everybody. Welcome to Trial Alchemy. I'm your podcast host, Monty McIntyre. I've been a California trial lawyer just a couple of years since 1980, and I've been a member of the American Board of Trial Advocates at BOTA since 1995. Most of my time I spent as a civil trial lawyer representing plaintiffs and defendants in lots of different cases. These days, I help lawyers get excellent results in three different ways. I help them settle cases as a mediator, decide cases as an arbitrator, and decide issues as a referee at ADR services. I make it easy for lawyers to keep up with the new case law in their practice areas with my online publication, California Case Summaries. It provides one paragraph summaries of all the new California civil cases, helping lawyers save time, win more, and get better results. I also make it easy for lawyers to learn to become better civil trial lawyers, both with my trial mentoring services and with this podcast, where I talk with ABOTA past or present members who are plaintiff or defense lawyers, civil trial judges, and we talk about what works and what doesn't work in civil trials. Now, today, it's my pleasure to have as my guest George Fleming. George has been a civil trial lawyer longer than I have, and he's probably tried more cases than I have. George has a very distinguished background and expertise and resume. He is a fellow in the American College of Trial Lawyers. He was a longtime member of ABOTA and was the chapter president in the San Diego chapter and served on the local San Diego chapter board of ABOTA. He was the president of the San Diego Defense Lawyers and served on that board. He was on the board of the Association of Business Trial Lawyers in San Diego. He was the past president of the San Diego Barristers and served on that board. He also served recently as the president of the La Jolla Bar Association. And he's been an adjunct professor at USD School of Law. George has tremendous wealth of experience. He started off doing primarily insurance defense work with a well-known firm called McInnis, Fitzgerald, Rees, Sharkey McIntyre, which had numerous excellent civil trial lawyers. Then he formed his own firm called Chapin, Fleming Winet, and they did primarily insurance defense. And later he moved to a large national firm, Baker McKenzie, where he handled all kinds of different kinds of civil and business kinds of cases. So without any further ado, George, welcome to Trial Alchemy. I'm glad to have you as a guest today.
Thank you, Monty. I appreciate being asked.
Well, let's start off right with this. You've tried a lot of cases in a lot of different areas. And what's an example of one of your satisfying trial results that you've experienced?
I got to preface this by saying I have absolutely loved what I do from the beginning up through today, and we're approaching like 50 years now, so it gets to be a little scary. But it's wonderful because people come to you in their moment of crisis or need, and they need your assistance. And in many occasions, I've been able to change people's lives or remove some danger from their financial or other lifestyle. So it's a little hard to pick one satisfying. There's a whole bunch where I've made a difference in a family's life or a company's longevity. But one that sticks out in my mind was a case where I represented a lawyer who'd actually won the trial. And he came to me emotionally devastated. He had put his heart and soul into this trial. He had thought he'd become friends with his clients, and actually was so devastated that during the trial, after he'd been on the stand, he called me at noon and said, "I'm not coming back to trial anymore." And he was never back for the last week of the trial.
Wow.
Yes, no, it had absolutely blown him up that he'd worked so hard, and then these people were down on him. But the backstory is he was representing a naval chaplain who had been charged by the JAG with taking undue advantage of enlisted men, both with his rank and his position.
Hmm.
And my guy got him off, and he had done it all for a flat fee of $60,000. And after it was over, they decided that sure looked easy. He obviously scared us into paying him 60,000 when it really wasn't anywhere near that challenging. And my theory is what happened is afterwards the wife turned to the husband and said, "Why in the world do we pay the guy 60,000?" He went, "I don't know. I really didn't do anything wrong." And it went from there because they both came to trial and sat next to each other. But I got the judge to agree that the only way I could show how hard this was to allow the JAG court to prosecute him again in the civil trial. And the JAG court was beside themselves with getting another shot at this guy. So they flew in witnesses and brought in evidence and just put on everything you can imagine to convince a jury that this was, in fact, a hard and valid case. And what I enjoyed watching was at the plaintiff's counsel table, you had the chaplain in his uniform with all these crosses, which of course made for interesting voir dire. But his wife was sitting right up next to him at the beginning of the trial. And as the evidence started coming in, you could see this gap expanding between where their two chairs were seated, because I think she was getting the message that uh, her husband was
Uh,
not so great. And then, like I said, after my guy testified, he said, "I can't take another second of being criticized and being called these names and stuff," because they were suing him for fraud. And I just can't come back. And I said, "Well, this is a jury trial. It's not going to look so good if I just have an empty chair." And he said, "I just can't." And he didn't. And fortunately, the jury saw how hard the case actually was. And we got a defense verdict. And he was so grateful. And you could tell he was like a changed man again, because he'd been thinking about giving up the practice and all sorts of sad things. So to me, that was probably the most rewarding.
well, that's a great example. And I agree with you, George. I think one of the wonderful things we get to do as trial lawyers is we can really make a difference in people's lives. And when you get that opportunity, that I think that gives you much more satisfaction than how much you build on the case or necessarily just a win or a loss. You made a difference to somebody in their life. So that was a great result you got for that client. Let me ask you about this. When you are in a trial, you're not going to go into trial cold. You're going to be prepared. And as you and I know from many, many years of trying cases, it takes a lot of work to get ready for trial. Now, I know that good trial lawyers will probably prepare for trial from the beginning when they start working on the case. They're thinking about the trial. But what I want to ask you about now is when we get to that point where you know this case is really going to go and it's time to do your final trial prep. I don't know whether it's a month before for you or it's longer or whatever it is. And I know sometimes you probably had to come into cases with not that much notice. But
Yes.
when you're in that final prep time, what's your process? What do you do? And what do you make sure you're getting done? So when you go in that courtroom, you will be ready to start.
Well, this is important because I see a lot of people come into the courtroom and I guess they think they're going to prepare as they go along, or they're just going to half-ass it, and they've always been good on their feet, so they will charm the jury. Preparation makes all the difference. And I've seen so many cases where uh, it probably influenced the outcome by not being prepared. So I put great stock into it. I don't have a set amount of time. It depends really on the case and the complexity and that sort of thing. But I start out by interviewing everybody who's touched that case on my side. And I take them one on one into my office and I get all their views. What are the strengths? What are the weaknesses? And what would you do at trial to make it more effective? And you would be amazed what comes out that even when, and you're right, I'm thinking about it for a long time before that, but what comes out that hadn't crossed my mind as a good tactic or a weakness or something. I then have and I don't usually use a laptop for it because I'm kind of old school. I use a notepad, but at the top of each page, I put an issue. And then as I go through my preparation, I find on what page, what issue that testimony or that exhibit belongs. And so by the end of my process, I've got a ready to go list for each issue of um, what we have, the other side has, and what's going to go on there. And it just makes your preparation of examinations easy. It makes your opening statement easy. And I don't just read page and line summaries on a deposition. You don't get the flavor of what the witness has truly said unless you actually read it yourself. So I always read them from beginning to end myself. And then as I'm doing it, obviously I put anything that I find interesting on that issue page where it belongs. And I put the page and line notation next to it. You've got to have those right at hand. I sat for 6 weeks on a murder case, and the one thing that blew me through the roof was lawyers on both sides. They would think they were going to impeach a witness, and the jury would sit there for like 3 or 4 minutes while they shuffled through the transcript trying to find where the witness said that. And I'm going, this is an easy part of preparation. So you got to do that. And then also, part of this is you probably have a lot that you could put on as video. I think if you put on too much as video, it becomes stale. So I generally limit that to the really most salient facts that you put up their face, and the rest of them I have them read and um, and do it that way. Um, One of the parts of preparation, which is most fun, I think, is being creative with the exhibits. If you can get the right exhibit to do the right thing, you can win the case or you can do very little. And I've got three examples. The first, I represented a aluminum ladder company and all their stuff out here. And people don't realize it, but these extension ladders are on an A-frame like this. So they don't fold out. And this one plaintiff was saying that I was standing on the third rail from the top and it all buckled. And there's no way that an A-frame buckles. But rather than have an engineer come in and explain all the forces and the diagrams, we put a ladder in there in a video with a little industrial tray hanging from that step that he was on and started adding weights and more weights and more weights. And pretty soon we were double what the guy's weight was and still adding weights. And the ladder's just sitting there. And the jurors are getting fixated on this thing. How many weights will it do? And it got up there and got up there, and at some astronomical weight, the ladder started creaking and stuff, and you could have heard a pin drop in there because everyone was just waiting. Well, how much is it going to hold? That was a case where that video won the trial. We didn't really have to do anymore. And I had a case, a wrongful death case with George McClanahan involving the death of a young mother who left two young boys. And I came to trial on the first day, no boys. Came to trial on the second day, no boys. And now they were becoming the elephant in the closet because in everybody's mind, poor boys left without a mother. Third day, the start of the trial, the doors open and in walk these two little boys holding hands with their dad, the cute as a button. They walk down, they sit next to George McClanahan. He puts each one on a stand for about 3 questions. Then they get up and they leave. And we never see them again. They weren't there long enough for a jury to get used to them or for them to get stale, just long enough for the jury to fall in love with them and have this picture in their mind, and then they were gone. It was genius on McClanahan's part. He was one heck of a lawyer. And if I can digress for a second, that case went up to the Supreme Court, and I was making notes just before my case. And as I stood up when we were called, I realized that I'd made those notes with a red pen, and I stuck the red pen in my pocket without putting a cap on. So as I stood up to go argue to the California Supreme Court, I had this giant red circle on my shirt there. Fortunately, the justices kept a straight face and didn't comment on it. Um, the third way we used nonverbal exhibits was a case where a fellow was backing a motorcycle down a ramp out of the back of a pickup truck out of a bay where there were a bunch of bays in a row on this alley. And unfortunately, at that same moment that he was backing the motorcycle down, our 18 wheeler was coming along right along the front of those. And of course, he continued back and things didn't go well. And so their theory was we should have honked our horn. And our theory was you don't need a horn with an 18 wheeler back there to know that it's there. And so at trial, the judge let me demonstrate that. And we parked all the jurors out at B Street and State on the corner. And we let them stand there for about a minute. Then I gave the signal, and you could hear this 18 wheeler rev up over on Broadway, 2 blocks away, and make that turner and come rumbling down B towards these people. And it just got louder and louder and louder. And by the time it was there, these people were all 3 or 4 feet back on the sidewalk. And there wasn't any further argument about whether we needed to honk the horn or not. So it just needs a little creativity to find ways to do these things better than just having people talk about whether you need a horn or you got a noisy truck.
Well, that's great. So I agree with you. I think preparation is the key. If you're going to be a good trial lawyer, you want to know where all your exhibits are. You want to know where every bit of impeachment is. You want to be a good flow presentation, and you don't want to make that jury sit there and be fumbling around for minutes while you're trying to get something going. So I agree 100% with that. Now, we're talking about trial preparation, and we're going to start talking about the trial. But I now want to ask you another question, which is there are many aspects to trying a case, from the beginning in picking the jury to the end of the final argument. And over your years of experience, George, and been on both plaintiff and defense sides in lots of different cases, which part of the trial in a jury trial do you think is the most important part and why?
Things have changed from when I first started out. When I first started out, the judges gave you a lot of latitude to argue the heck out of your case in voir dire. And if you did it right, you could pretty much have the case over. I once had one case where, when I'd finished the trial, Karen Webster, who was the clerk for uh, Judge Lou Welsh, brought me a note and said, the judge gave me this right after you finished your voir dire. And a note says, this case is over. And so you could have fun in voir dire if you had the right jurors and you had the right questions and stuff. So I always looked forward to that. But nowadays you have to examine so many people so quickly, and the judges really clamp down on all that. So I think the opening statement is really where you've got to sell your goods right out of the chute before the other side does. So reluctantly, I defer from voir dire to opening statement.
Well, nothing wrong with that. Things can change over time. So in trial, you've got a jury and they're watching everything. So lawyers, in my experience, lawyers aren't often enough aware of this. How important is it for the lawyer to realize in the courtroom that everything they do is being observed and somebody's going to see it?
Yeah. I think at some point we realized during a trial that the jurors are identifying with you as the party rather than the person sitting at the table.
Yep.
And so you've got to maintain that credibility and respectability all the way through. And the slightest slips can cause your client lots of points. So, you have to be polite and respectful, of course, to the court, but also to counsel. I once was in a case, and the other lawyer's case was not going well, and he actually threw an exhibit over to me that went sliding across the desk. And I caught it with my hands, just simply went, "Thank you." And that was probably the final nail in his coffin. But witnesses will be abusive at times with you. Either they're being defensive, so they think they can get snarly or nasty, or they think you have a stupid question. There's a lot of ways they can really get on you. And the only way to deal with that is just to ignore it and just continue to be polite, like they haven't done it at all, and let it go at that. I think we do have a danger if we're too stuck to our notes in voir dire or in our examinations. It's almost rude that you ask somebody a question and then you're looking down at your notes for what your next question is going to be while he's answering you. I mean, if I was at a party and I asked somebody a question and they started looking down at their phone while they were answering me, I wouldn't take that well. And you just never know how that goes with jurors in voir dire or with witnesses on the stand. So you kind of have to be very polite at all times.
Yeah, I think you have to be very polite. I used to be thinking of it as when I'm going to try a case, nobody's going to out nice me. At best, it will, at worst, it'll be a draw. And what happens more often is the other side may be, inconsiderate, rude, whatever they are, and they're just helping you. And that's what you're saying.
Absolutely. You're you're either gaining points or losing points at any given minute in there by what you're doing and how you're doing it. And that goes back again to your page in line. You lose a ton of points if you're making those jurors on their time sit there while
Yep.
you go shrumbling through your transcript.
Yeah. And whether it's points or another thing, I've always thought of the trial process as my goal was to not give any gift to my opponent or points. And my goal was to take advantage of any gift or points from them. And that helps you get the best result.
It really does. And I think the more you ignore anybody's antics and just stay polite and respectful, the jury just loves that.
Yeah. And I think that's still true today, even though the culture has changed over the years.
A little bit.
A little bit. Now, George, one thing we were talking about before, but you may want to share is sometimes, even though court work is serious business, sometimes something funny happens. So you had some idea of something you wanted to share on that.
Well, I think looking for humor is always important. If you can find a way to inject something that's appropriate, but would give everybody a chuckle, particularly during voir dire, it lightens the mood. It makes you more human, and you score points doing that. Uh, so many funny things have gone on, but one that comes to mind there is uh, I was trying a case for Campbell Industries when they used to be in town that involved the propulsion system for a tuna seiner, easy for me to say. And we were in federal court in front of a judge named Fitzgerald, who'd been on the Alaskan Supreme Court before he became a federal judge. And most of these federal judges have a pretty good deal. They can come down to San Diego in the summer, bring their crew, and hang out down here. Well, unfortunately, our case was one that nobody local wanted to try. I mean, it was a bench trial, and it was scheduled for like 5 weeks, and this guy was down here for like 3 weeks. And the poor guy was working just night and day to get through it. And that's not funny. That was just sad. But the way it was set up is where he sat on the bench, his clerk sat in front of him. And every day, as soon as they got back from lunch, his clerk would fall asleep. It was just like clockwork. And there was one day when we got back from lunch, about the time he nodded off, we had to put a big diagram in the well. And the judge said, I'm going to come down and take a look at that. And the judge and the clerk by now is he's out of it. But the judge slides back his chair. And as soon as the clerk hears the chair slide back, he stands up, says, court will be in recess, because he thought the judge was leaving the bench. But funny stuff.
Oh, that's great. Well, George, you've had, and we'll talk about some other aspects of trying the case, but you've had an experience that I've also had. It's not always common for trial lawyers to get to sit on juries, but you've had an opportunity to sit on a criminal jury trial. And
Yes.
what did that experience do as far as your perspective on what the jury does when they're listening to a case and how they handle their responsibility?
Well, I had been brought up at McInnis like you to trust your jury everywhere. Don't ever take a judge, take a jury. And I had faithfully followed that. And it seemed to pretty much pan out that the jurors got it right. But this was a 6 week murder case. And when I started looking at my co-jurors as they were being selected, I went, that guy's not going to be able to keep up, and that guy's not going to contribute. And this is going to be way over that guy's head. I mean, I was being a bit of a snob. And when we got back into the jury room to deliberate, it was absolutely amazing. Every one of the 12, from their different backgrounds and experiences, had picked up on things. I mean, this was 6 weeks of trial. And putting all those pieces together, we were able to put the puzzle together and come up with the right decision. And I appreciated every one of those people. And it just, uh, after that, I knew that jury systems really do work, unless it is just so incredibly complex that no normal layperson could understand it.
Well, that was my experience. I got to serve on two criminal trials, one a
Wow.
short one and one a longer one, not as long as yours. And I had the same impression from both those juries. I thought they really had great insights. They all paid attention. And when you have 12 people and all those people observing and noticing different things and coming at it with different perspectives, the system works and it works very well.
I think it does.
So now that you're getting ready to start your trial, you're fully prepared, and we're going to start the voir dire. Let's talk a little bit about the voir dire process. So you're going to be talking to potential jurors, and you're going to be trying to create some kind of a connection with them. But what is your tactical approach? What are you trying to accomplish? And depending upon the nature of the case, what kinds of jurors are you looking for? And you may have different things you're looking for in different kinds of cases.
Oh, absolutely. It depends on the facts of each case, who's going to be supportive and who's not going to be supportive. But if I can back up for a second, for those that might see this that have not done a voir dire or have only done one or two, I've used a system the entire time that has never failed me, and that is you put stickies on a notepad, one sticky for each person as they come up, and that way, if they get booted off, you take off the sticky and put the next person on. The reason I would do it on this way rather than on a laptop is at some point you're going to have to get up and ask your questions in front of these people. And if you're lugging around a laptop and trying to type it with one hand while you hold it with the other, you're lost. But the old tried and true way works best. So I have these stickies, and if there's something that the witness says that I want to remember, I write that down in black. If that person says something that I want to ask them about, I write it down in red. And that way, when I get up there, I don't have to worry now, what was I want to say? Like I just look for all my red things. And then at some point, I give them a rating. They either get a plus if I think I could keep them, a zero if I'm neutral on them, and a negative if I don't want them. And sometimes that is the biggest blessing because when you come to the end, some of these judges want to run through the excusing real fast. And if you've got this, then you can pull up very quickly who it was that you didn't want to get hold of without having to think about it too much. Um, but once you get going, if you can find that juror, the diamond in the rough that has some uh, similarity to your client's situation or has been involved in that, um, don't be shy about mining that for all it's worth because the other side's not stupid. I mean, they're going to get rid of that person. So you want to go through as much as you can and your points with them. When I was starting out at McInnis, they started you out with cases with a magnitude of exposure commensurate with your experience, which I'm in this trial, which is about zero. And it was a plaintiff that was suing because she had been arrested for stealing like a dime piece of something or other. So she was suing the store. And lo and behold, one of the jurors was a clerk in a store like that.
Mm.
And so I started asking her, well, do you get a lot of this? Yes. And doesn't it add up a lot? And the more it adds up, doesn't that affect profits? And don't profits affect salaries and bonuses and all that? And it took this 10-cent thing and suddenly made it huge. And that was the case where Welsh put the note saying this case is over when I'd finished. But once one person has bought into that, then you want to make it a group belief. So you ask two or three around there, well, don't you feel the same? And you get two or three, it then becomes the common knowledge that that's what goes on. Um, I also use voir dire to get out bad things that are coming up in my case. I
Yep.
mean, a juror's thinking, well, if Fleming's bringing that up, how bad can it be? And also things that you know the other side's going to try and do. There's one lawyer in town that was notorious for always crying in his final argument. So in my voir dire, I said, if some lawyer should start crying during this, is that going to affect your decision making? And sure enough, the waterworks came on in final argument, and the jury was waiting for it. I mean, if you talk about losing points, as soon as he did that, his whole credibility went in the dumper. So if you think ahead on these things and milk them for all you can, it's great. One area I should talk about is for cause.
Yeah.
Cause is where you can dump a guy or girl without using up one of your valued peremptories. But you've got to be able to show that this person is not going to follow the law or the judge's instructions no matter what. And so usually when you sense that you've got one of these people, you dig it in with the thing that they are not going to change their mind on is a core value of theirs. And if they were to move from that core value, they would be betraying themselves and their beliefs. So therefore, there's nothing a judge or an order would do to change that. And if you get them that committed that there's nothing anybody could do, you got a decent shot. Now they're going to get barraged by the judge and by the other side saying, you mean if I give you an order that you've got to do this, you won't obey it? And hopefully you've got the person committed enough that this is a core value that they'll say, I just can't. But sometimes that comes off. But you don't rush up to the judge as soon as you've got this person locked in. You wait till you finish all your questioning, and then you ask for a sidebar. And then you go up and you talk about it and see if you are successful or not. That way, if it's not for cause, your motion for cause isn't granted. You don't have an enemy for life because the juror doesn't know that you went up there specifically for him. So you just wait until all your questions are out, and then you run up and tell them.
That's good advice, and you really have to make sure you ask all those questions because you know darn well the judge is going to try to rehabilitate them
Oh,
and
every way possible.
keep them on. Well, in terms of picking the voir dire or picking the jury, um, and this could be whether you're doing defense side or plaintiff side, were you looking for any particular kinds of things in jurors that you thought were pluses? What kinds of things were you looking for that you thought were good?
You can usually tell whether somebody believes in suing or doesn't believe in suing. And depending upon which table I'm sitting at, I either work that one way or work it the other way. But nowadays, you get so few questions that you really can't milk that like the old days. But I'm
Right.
definitely going to explore that a little bit and probably see if I can bump off the ones that feel the other way on that. But that's the most one I'm looking for, and also people that have experience in that particular thing that we're talking about, uh, either that industry or that manufacturer, whatever it may be, uh, and what their experience was. Were they happy there, sad there? Did they think it was honorable? There's so much you can do if you have the time. It just it's too bad. That was a lost art.
Yeah, you don't get that much time anymore. That is certainly true. So now you've got your jury, you got your jury picked, and now you're going to give your opening statement. Maybe you're the defense lawyer, maybe you're the plaintiff's lawyer. What is your strategy in your opening? And you've said earlier you now think that's the most important part of the trial. So how are you trying to get your story across and make the right kind of first impression when you really talk about the case in detail?
There's a real danger since you've been living with this case for 2 or 3 years that you're too familiar with the facts, so you assume some total stranger immediately is going to understand the significance of everything that you're saying to them. Whereas generally, if you start that way, they're totally awash, not having a clue why you're telling them all this and how it fits together. So for most cases, a story in chronological order makes a lot of sense because it's easy to follow. Sorry, sorry, Monty. I got rid of all the phones in the rooms and forgot that I had my mobile phone in here.
That's all
Anyway,
right.
so uh, what was I just saying? I'm blocking that.
Let's see.
Oh, I know. I was talking about it being doing it in chronological order. For most
Right.
people,
Tell your
that
story in
makes a lot of
chronological
sense,
order.
and that way a jury can follow along with it. Here again, though, your familiarity may cause you to throw in more facts than a juror can digest in a first sitting. So you kind of want to hit them with the most important, most powerful ones and leave all the other minutia till a later time when it just kind of settles into examinations of different witnesses. I always leave something back, a couple bullets or surprises for the trial itself. I don't want to give the other side a complete roadmap to where I'm coming from in the voir dire. And this is very important. Do not write out your uh, opening statement. Don't take it up there because if you do, you're going to start reading it. It's just human nature that at some point you're going to start reading it. And once you start reading it, you lose the jurors because you're no longer one human telling others a story. You are somebody reading off a piece of paper because you don't know your case well enough that you can do it without reading off that piece of paper. And you lose credibility there too. I mean, they want someone that's going to look them in the eye while they're telling a story because that means you're telling the truth and it's coming from your heart. If you're just buried in your notes, don't do it. Now, I'm not saying don't have any notes at all. What you need is a list of points so that you don't forget anything. But that point should only be 1 or 2 words just so that when you see it, you go, oh, yeah, now I got to get to that and you can run through it. Um, I think there's a danger in overusing video in the opening statement. I would use it very sparingly because it becomes stale, and you kind of want to have its star impact when you're actually in the case and examining a witness. Here again, you want to address the bad facts, put your spin on them, try and disarm the other side's case. And usually, like I said, a chronological order is the best way. Now, if you're dealing with a contract case or a transaction, a lot of times you want to do it on an issue by issue basis.
Right.
And chronological just doesn't matter. It doesn't really compute. You have several issues that you need to address, and you just take that sheet I was telling you about in the beginning that has the issue and has all the things behind it, and go down that and don't list every single one. Just take some of the most important ones that back you up and mention those.
So in your opening statement, and we'll talk about this when we get to the final argument, but are you presenting yourself in terms of the way you're talking to the jury in a different way than you might later in the closing? And if so, what is it? Or are you the same in both?
I try and stay the same from voir dire. I'm hoping that I've been able to inject a little humor into voir dire and that these people like me. And if you change, then they don't know who the person is that you now are. And so it's like a stranger has appeared in the case. So I try to stay in form from beginning to end and hope that I've read the jury right, that that's going to fly okay.
Well, I agree with that. I think that what I've done with opening statement compared to final argument is I try to be pretty reasonable in everything, but if I'm going to show a little more emotion, I'll show more emotion at the end after we've had the time together. And I'm not going to do that maybe in the opening because you've been working with this case for years as a trial lawyer, but the jury is just first learning about it. And so I think you could maybe show some more emotion depending upon how you view the case in a reasonable way. But that's what I'm thinking about maybe being a little bit different.
Yeah, no, that's a good point. I try and get across that I am fully invested in the case and fully believe in the case right from the get-go in your opening statement. There may even be a little emotion in there. I know my voice will be stronger at times when I'm going on something. I don't want there to be any mistake that I'm not just there because I'm getting paid and saying these words. But you're right. I mean, I could step it up a little bit more in final argument, and I probably do and don't know it.
Yeah, we probably all do and don't know it. So now you've given your opening statement. You're going through the witnesses, whether you're first or second, depending upon plan for defense lawyer. And your witnesses are going through direct exam, and then it's time to cross-examine the witnesses. So, what is your approach to cross-examination, and what are the ways you like to impeach the witness when you've got them based upon their depo testimony and all that? How do you go about that in your cross?
Well, there's no secret about it. Anybody who's tried a case as a co-counsel with me knows I just wait for the cross-examination. To me, that is the most favorite part of the trial, and I love it to death. I keep a very tight control over the witness. I know some people don't, but I think there's a danger in letting them wander because they can slip in things if they're cagey. Um, I've got my page and line outline there, which has in it the answers that I expect them to give to everything that I ask them. If there is a really critical question and I think they may dance on it, I actually write that question out verbatim so that when I read it to them, impeaching them, there's no question in a jury's mind that what they just said in answer to my question in court and the answer they gave in a deposition, the question is the same and that their answer is different. So you don't want to leave anything to the jury to try and figure out. But that's so clear. If you ask the question verbatim, then you read the question, it's they know what's going on. Um, when you're doing the depositions, there's two things you got to be sure you cover in there. One is don't guess, and the other is state it if you don't know, because when you've got the person trapped at trial, those are the two escape hatches. One is, well, I was just guessing. And the other is, I really didn't know. And so if you have them already committed that they're not going to do either one of those, you've shut the door on the escape. And sometimes when you ask them to read from their transcript, they'll either read real fast or real softly, so the jury just can't get what it was that their answer was. Don't be bashful about asking them to read it again a little louder, a little slower until you get it. A couple of tricks that I like to do is you'll have jurors that are combative, and you have a question that they know they're nailed if they answer it. So they will answer anything else but the question that you're putting to them. Uh, the way I respond to that is I ask the exact same question again, just as politely as the first time. And if they skitter around it again, I ask them the exact same question, just as politely the third time. Now, at some point here, the jury's on my side. They're going, give the guy his answer. What's wrong with you? Are you trying to hide something? And it becomes very apparent that this witness doesn't want to own up to whatever that question's asking. And
Right.
usually, after you do it about 3 times, the judge has heard enough, and he'll turn to the witness and say, "Look, answer the question." And then the witness can't skid around anymore. They've got to do it. The other trick I use is with the person that thinks they're going to be clever with you and use the, well, I can't guess answer. And I refer to that as ask them to climb the ladder. And here's a simple example. You ask them, well, did the child eat 2 Oreo cookies? They say yes. Did he eat more than 3? Yes. Did he eat more than 4? I don't know. Did he eat more than 5? I don't know. Now they think they're being clever with you because they think they're doing the right thing by not guessing. But by the time you get up to, did they eat more than 10? I don't know. Did they eat more than 12? I don't know. Most jurors will just stick to their guns. They aren't going to let you force them to answer the questions. You get up to these numbers like, maybe 15 cookies. And when they finally realize where they are and they go, well, wait, I know it wasn't 15 cookies. Then you say, so the best you can do is tell us that the amount that this child ate was somewhere between 3 and 15. And they either have to live with that or they say, well, no, it was probably more like 7. Then you go, yes, but I just asked you if you ate more than 8 and you said you didn't know. So which is it? And either way, there's no way out. So it's kind of fun, and they think they're being clever and smart, and it just saws them off at the knees.
That's, that's why crossing's fun.
It's so fun.
So when you're impeaching the witness, it sounds like, do you ask them to read the question and answer from the depot transcript, or do you read it?
I
Or
usually
you
leave a copy of
don't?
the transcript up there for them, and I read it rather than them because uh, it just goes smoother and it's clearer. Every once in a while, if it's just a real gotcha, I'll ask them to read it. And that's where you get the real soft voice or the real fast reading. But most of the time, just to keep it under control and keep things moving, I'll do it myself. And here again, I those lawyers in the murder case I was on lost so many points by shuffling through their transcript trying to find where that thing was that they wanted to impeach on. That don't ever do that. Jurors are there on your time. And so they expect you to make every second count.
And talking about this and knowing where the testimony is, that goes back to your preparation point, and I agree with you. You need to read the deposition yourself as the trial lawyer.
Absolutely.
And I don't know about you, but when I've had people who have helped with page and line summaries, I have trained them to say, you need to do the exact question and the exact answer. I don't want to get your summation of them because you need to know if the questions and answer is going to be a good one for impeachment. If the witness gives an answer in deposition that partially answers your question and then goes off into another area, that's not going to be good at trial because you'll have to read all that. You have to make sure you nail them down with a clear question and a clear answer, and then you have that impeachment for trial.
You're more trusting than I am, Monty. You're a good guy. I don't usually believe that someone else is only knows part of a case or doesn't have my experience is going to be as sensitive as I am to the little subtleties that might be at the end of the answer to a question or the attitude that that question's putting out there. And so I have to read it myself to know how they're doing it.
I actually agree with you, and I've always read the depots myself. It's just if you're having somebody pre-trial do summaries, they really at a minimum have to do verbatim page line. And I still think the trial lawyer has to go through and know what every one of those depositions say and make their own page and line. So I
Right.
agree with you 100% on that.
If they're going through it verbatim, you might as well just take the transcript.
Yeah, yeah. Well, in terms of your presentation of the case, and we've been talking about cross-examination, I'll bet in some of your cases, sometimes the case is won or lost on what happens in cross.
It can. I had a huge case at Baker McKenzie where what was at stake was the sale of a whole division of an airline.
Mm.
And Baker told me, you've got all the resources you want, just win this case. And it had mega millions at stake. And the background story is our client was a foreign airline, and they were selling this division to a rather skunky, well, I probably shouldn't say that because he'll probably watch this, but to a lawyer in a group in California. And the Californians drafted the contract in English, and the guys in a foreign country figured they were conversant enough in English that they could do it themselves without having a lawyer review it. So they saved maybe $25,000 on
Oh,
the review and ended up in a court that was not where they wanted to be with huge amounts at stake. And I had figured out and kept it to myself that the buyer had a bridge loan, which is it gaps from where you start out to where you get to the final deal, but it is not the final financing. You have to have someone else then say, yes, we're going to finance it. And so I kept that in my breast pocket until the buyer was on the stand. And we went through the whole thing. And then I said, now this bridge financing anchors you until you get the firm financing. And he said, yes. And I said, and you did not have an indication from a firm financing company that they would actually do this, did you? He said, well, they said they would. So you didn't have it in ink. They could have backed out at any time, right? And nobody saw that coming. But then I made a motion for non-suit that they couldn't prove that they could have closed the deal. The judge bought it. And they were kicked out. And this was after each side had spent over $1 million in trial in the courtroom. It was up in LA, and
wow.
our army was up there, and their army was up there and battling away. And it's just funny how you can make these things evolve like that. So,
Yeah, you can really make a difference there. So in terms of you've gone through the trial and you're getting to the final argument. What's your strategy and approach in your final closing argument?
Well, first, here again, and I'm a broken record by now, but for your younger lawyers, do not write out your final argument. Just again, have a issue list, because particularly here, when you're arguing what has gone on and how you believe they should go, you've got to be looking them in the eye. If you're reading or you're looking down at your page, you're not selling yourself as believing in your case. So you've got to know it backwards and forwards, and you've got to be able to do some fast footwork if the judge suddenly throws a zinger at you. I had a case where on a Friday we had sent the jury out or home with all the arguments finished. Monday morning we came in, the judge said, "You know, George, over the weekend I thought about it. I'm going to find your client is liable as a matter of law." And I said, "Judge, on Friday I argued my client was not liable. And what is this going to do to my credibility?" And he said, "Well, don't worry, you can argue it again." What are you going to do? So you got to be ready. I got up and argued the rest of the case again. And fortunately, the jury was going my way anyway and awarded like $200 for what the judge had done. Amazingly, I had a fraternity brother on that jury,
Wow.
and the other lawyer knew about it and kept him on. No, I don't think he, well, I don't know if it had any things at all, but I was in a fraternity up in Los Angeles. One other time I had a fraternity brother show up on a jury too. And I mean, we weren't a particularly big house when you think of all the thousands of people that go to jurors. So
Right.
anyway, um, you got to be flexible. I structure the final argument uh, unless it's maybe or maybe not, if it's a business case and it's a contractual issue or a transactional issue. But for your general tort case, I follow the verdict form and I go through it from question one
Yep.
all the way through. And for each one, what witnesses, what evidence should guide their decision on that point until I've gone all the way through to the end. Here again, for a couple of the really important points, I will put on a video of the witness doing it, but you can overdo it. You can make it stale and it slows the things down, waiting to get that thing set up. Um, I usually pick two or three key jury instructions, which I read to the jury at the time it's germane to somewhere in the verdict form. And keep in mind that whoever goes first um, has to say what they want to say there because you can't say something for the first time in rebuttal unless the
Right.
defendant has raised it.
Yep.
And every once in a while, a plaintiff lawyer will think he's being clever by saving his demand and his numbers till the end of the case. And if the defense lawyer is on his toes and doesn't mention any numbers, when the plaintiff tries to put some numbers in there at the end, he's shut down. I always think you've got to put numbers in if you're the plaintiff in your case. But that's pretty much how I approach the final argument.
Okay. Um, we're getting close to the end here, but I wanted to let you talk about some other things. You wanted to mention there can be embarrassing moments in the courtroom, and what did you want to share about that?
Well, briefly, back in the 80s, we had a real crunch in San Diego. And so they were asking lawyers to sit as judges pro tem for jury trials. And I was in the middle of one, and I came out in the morning on Monday. And there was a note saying, "Dear Judge, we used your courtroom over the weekend for the inn of court, and we tried to leave it as clean as it was." So I looked all over the courtroom, be sure there wasn't anything that shouldn't be there. And the only thing I saw was some scribble on the cork board. So I took that down, folded it up, and put it in the trash. And the expert who'd been on the stand got back up there and he's looking all over. He's looking in his briefcase, he's looking around the room. And finally I said, can I help you look for something? He said, yeah, I had a chart up on that board and it's not there now. Trying to explain to the jury how his chart ended up in my wastebasket, but it did not reflect on his merit of his opinions or anything else. It was a bit embarrassing. The other very embarrassing thing was I was representing a grenade manufacturer in a case where the grenade had exploded while it was being fired by a Marine. And I had a mock-up, steel, real-looking mock-up, and I put it in my briefcase before I was going to go down to a settlement conference and forgot all about it. Didn't think about it again until I went through the scanner. And suddenly you can imagine how that lobby down there went crazy. So,
That was that created a lot of excitement.
oh man, that's an understatement.
So, did you wanted to say something about most important trial?
I think the most important trial I had was a man came to me who was absolutely desperate and despondent. He had been driving a Jeep that, according to the police, had gone over the center line, hit another car head on, and killed the driver. And he was
Wow.
being charged with manslaughter. He had been to three lawyers who had all said, sorry, can't help you unless you want to plead. And he was telling me, and he's a pretty level headed guy. He said, George, I remember before the impact seeing the headlights lighting up the trees. And I said, so what do you take from that? He said, well, the axle broke before impact. So we had the axle looked at by three different experts. Each one said, no, the axle broke during the impact from stress. And we got a fourth expert. I don't know how the carrier got talked into four, but on the fourth one, he looked at this little keyhole in the axle that is cut. And instead of being straight, if it's straight right where the two meet, you get a stress and it breaks. So what they do is they put a curve right there where the two corners meet. It's called a fillet, and that keeps it from breaking. This particular cut on this axle did not have that. And once we were able to show that that's why the axle broke, that's why he could see the light in the trees before the impact, as the axle had broken going around the curve. Not only was he absolved of the manslaughter and the lawsuit against him, but we actually recovered money on his behalf from the manufacturer of the axle.
Good for
So,
you. That's an outstanding result.
well, it was very gratifying that somebody who was so tortured by all this and no one would believe him suddenly was vindicated.
Another example of how you can make a big difference for people in the work of being a trial lawyer. Well, George, this has been a great conversation, and there's a lot of very terrific information that you've shared. And before we end, I want to ask one last question, and that is, you've been trying cases for many years. You've been trained by people when you were younger who were excellent trial lawyers. If there's somebody who wants to become a trial lawyer, maybe they haven't tried their first case yet, maybe they've tried just one or two, what advice would you give them about how they should go about trying to be the best trial lawyer they can be?
Well, there's a whole spectrum of specialties you can get into in the law. And I think there's a specialty that fits every person's toolbox and their personality. If you find it, you're going to love doing what you do. I have loved every minute of this because just by happenstance, I ended up at a firm that did this sort of thing and got hooked on it. But sometimes I go down to court and I look in the eyes of the man on the other side. He may not be young, he may have been there a long time, but I can tell he does not want to be there. And it's not because I'm there, it's not because of the case, it's because he doesn't like being a trial lawyer. But it's a very slippery slope. I mean, as soon as you get out of law school, you start incurring obligations financially, and these grow, but you're also developing contacts and your salary's going up each year. It gets harder and harder each year to suddenly realize this is not what I want to be doing. I want to be doing some other type of law. So please, if you're thinking about it and realize you're not where you should be, get out of there. Even if there's a horrible financial impact on your family to do it, it's not going to get better. And you've only got one life. Find the area of the law that is good for you and love it. Now, some people avoid litigation because they go, "Oh, I just get so nervous." Well, I remember driving down for my very first trial the whole way praying that there was going to be a natural disaster, an earthquake, that the power was going to go off in San Diego. Somehow I was going to have to get up and face this jury. And there was a fellow in Monty's in my firm called Gary Bailey, who was one of the best around. And he always said, the day you don't feel nervous before you start trial is the day you should hang it up. It's like the pregame jitters.
Yep.
You have them every single time. And so the fact that you think you're going to be nervous, welcome to the club. We're all there. But if it's not that, if it's that you don't want to be doing that, then get out and go somewhere. Now, if you are going to be a litigator, all the sort of cases that I grew up on and Monty grew up on are long gone. I mean, they're all arbitrated, mediated. It's all kind of medium-sized cases and greater that are out there. So the ways to get your trial experience are one, see if you can second chair for people in your firm that are going down and trying a case. If you're a sole practitioner, find someone that's going down on a case and see if you can second chair for free. At the very least, just go down and watch some trials. If there's lawyers that you think you'd like to emulate, go down and watch how they do it. You can learn a lot by watching it, but watch the trial from beginning to end. You can't just go down, see one piece and know how it fits together. San Diego has the Inn of Court. Others do too. It'll give you some familiarity with some aspects of it. I think which is a much more helpful program when you're starting out is NITA, the National Institute of Trial Advocacy. There's chapters all over, and they actually take you for a week and start you with each component of the trial, and you do that yourself with a fictitious case. And that way it's probably the same as having tried one or two on your own. But the one thing I would urge everybody that's starting out or just getting into it is a case called Reap the Whirlwind. It's written by Houlihan. It is about how Milt Silverman, who was probably one of the best trial lawyers we've ever had, how Milt would prepare a case for trial and how he went to trial on the famous Saigon Pen case. It is an education. I learned a lot reading it, and I think anybody, particularly when you're just starting out, seeing his approach to how you prepare for trial and how you go to trial is wonderful. And that about concludes my pearls of wisdom.
Well, George, it's been a pleasure to talk with you. The time has gone far too fast, but thank you for sharing all that you've learned over the years, and thanks for being a guest today.
Monty, it's been an absolute pleasure. Thank you so much for inviting me.